Is there a claim that the charges themselves are fraudulent in some way?
One thing we might seek down the road is an itemization of exactly how this child support is being spent, this $5,392 per month.
Dr. Cole makes probably at least 4 times as much as my client. I'll just go through, for example, a list of expenses for these children that my client has borne the sole responsibility for.
It's been tough. Chris doesn't help with any support for anything extra on top of the child support. And yeah,
Dr. Kroll has recently purchased $1 million house. My client recently had to sell the marital home that she was awarded so that she can support these children.
We have beliefs that this entire litigation is a attempt to increase the child support obligation.
A woman already getting $70,000 a year in child support brings her ex into litigation because she wants more. Sit through this one with a notepad out, taking notes into how a blood-sucking vampire will attempt to take everything away from you and has the absolute audacity and guts to ask for more. Without further ado,
Its objection to child care charges appearing at today's hearing via Zoom. There being no objections is plaintiff Emily Kroll with her attorney Melissa Umulis and defendant Mark Kroll with his attorney Jeffrey Norman. And Mr. Norman, you may proceed.
Thank you, Your Honor. Objection is based primarily on the following. First of all, there's a couple of provisions in the judgment of divorce that still remains in full force and effect. One of the provisions states it is further ordered that neither party shall seek a review of child support before April 30, 2025. The other provision that's relevant here is it is further ordered that if either party is unable to parent during his or her parenting time, and that inability includes 6 hours or more, the other parent will have the right of first refusal to parent the children during that time. Dr. Kroll was paying an agreed upon amount of $5,000 per month, and that's an upward deviation of about $1,600.
you guys heard that right. $5,000. Now, contrast to what you heard previously, demonstrating victimhood mentality as if he pays nothing or he doesn't pay enough.
Practically speaking, the objections are based on the following. This increases for childcare costs. The plaintiff works from home. The children are 10 and 12 years old. The 12-year-old is old enough to babysit other children, and in fact does babysit other children. And when she's doing that, she's not even attending or present for this childcare that they're requesting reimbursement for. And last, Dr. Kroll has people who are available to provide childcare to these minor children if it's needed. So that's the basis of the objection, Your Honor, and that's all I have.
Is this a situation where is there a claim that the charges themselves are fraudulent in some way?
I don't think, not fraudulent, but just other than what I've stated, we're not even certain that the 12-year-old is present during this time and these charges are in fact being incurred. One thing we might seek down the road is an itemization of exactly how this child support is being spent, this $5,392 per month. So we don't know if those charges are actually being incurred.
Okay. Okay, thank you, Ms. Umulis.
Yes, the assertion that one of the children is not present during the times the nanny is there is absolutely not true. Both children are present while the nanny is providing care. In fact, my client is only utilizing the nanny 3 days per week. She's employed full-time with Blue Cross Blue Shield. She has an extremely demanding job. She works 5 days a week, but is presently only utilizing the child care 3 days a week due to Dr. Kroll's refusal to contribute to any of the costs. So really, my client could be utilizing child care 5 days per week, and it would be extremely helpful for her to do so given the demanding nature of her job. but she's not at this point just due to the historical refusal to contribute. And this nanny that my client is using is the party's long-term nanny that they had used all throughout their divorce and their marriage. She's actually been the nanny for the children since Elena was about 3 years old. And with the exception of, I think, 2 summers, they have used this nanny every summer for childcare. And so this isn't a new childcare provider. This is someone that Dr. Kroll obviously agreed was appropriate to care for the children in the past. The right of first refusal provision that was referenced does not apply because Dr. Kroll is also employed full-time and is not able to provide care during the work week. And we also have a temporary order in place right now. So that order is the order that controls. I just like to.
So this man is paying $5,000 a month to this woman so that she can pay someone else to take care of their children. Can someone please explain to me, how the hell does this make any sense whatsoever? But let's listen to this lovely young woman explain how $5,000 is simply not enough.
No, my client submitted this documentation to front of the court for the reimbursement. The fact that we're here arguing over $392 a month is, I'm shocked that we're here arguing over this. Dr. Kroll makes probably at least 4 times as much as my client. I'll just go through, for example, a list of expenses for these children that my client has borne the sole responsibility for since the divorce. 100% of the nanny costs for childcare last summer, which she didn't seek reimbursement for. The GTAX tuition for the children for the 2021-22 school year in the amount of approximately $12,000 that Dr. Kroll refused to contribute to. School laptops for the kids, their cell phones and their cell phone plans, clothing, volleyball camp, which Dr. Kroll agreed to reimburse my client $80 for last summer and still has yet to reimburse her despite her sending numerous messages. Uninsured healthcare expenses. My client has paid 100% of the uninsured healthcare expenses for the children since the divorce because Dr. Kroll has refused to contribute, and she's submitted requests. He's demanded other itemized confirmation of payments, even though in the divorce judgment itself, it says that specifically plaintiff is not required to keep an accounting of expenditures for ordinary healthcare expenses. So this is a legitimate work-related childcare expense. There is nothing in the judgment or the deviation language that states that my client would bear the sole burden of childcare expenses. And in fact, she has been exercising significantly more overnights since the divorce judgment than was contemplated in the calculation when that judgment was originally entered. A good portion of that was based on Dr. Kroll's agreement. I understand there are other issues in dispute regarding the overnight time, but at least a period of that was by agreement. So she has really taken on the primary burden here of supporting these kids. Meanwhile, Dr. Kroll has recently purchased $1 million house. My client recently had to sell the marital home that she was awarded so that she can support these children and support, frankly, the cost of this litigation. So this is, I think, a reasonable request on her part that he contribute to the childcare expenses. They are legitimate, they are work-related, and she's only utilizing this nanny 3 days a week when in fact she could utilize, honestly, 5 days. And so we would request that adjustment continue.
Ms. Emulus,
And you're trying to tell me that $5,000 is not enough to cover all of that? And now the lawyer is poisoning the well, bringing up that he was able to get a new home after your client got to take their marital home and is now losing it due to her own incompetence. Now I understand why Dr. Mark is over there just smiling in the camera, because you guys are looking more and more stupid.
how does Ms. Kroll's work from home schedule make her unavailable to provide care for the children at the same time?
I can go through a summary that my client just sent me this morning of her job description. I mean, I think we all understand, work from home with kids, even, a 10 and a 12-year-old is extremely difficult. My client is on calls. She has things that she has to attend to, and she needs to be 100% focused on her job. So I guess just to summarize for the court, some bullet points on her roles and responsibilities with Blue Cross Blue Shield. She has a customer-facing role with several universities' HR leaders. She's responsible for handling student health plan benefit and plan inquiries, updating plan documents and digital content. She's the primary point person for handling critical and urgent inquiries from nearly 20,000 students and HR leaders. Ms. Kroll was just in my office yesterday and trying to juggle an emergency call with a university or to deal with university health insurance policies while we were trying to participate in the settlement conference. And so it really is like when these crises come up, it's urgent and she has to be on it. And it's not something where she can just leave a call or attend to the kids. She's also a project consultant for key and large group implementation and customer member education. And she coordinates resolution for complex claim and provider inquiries, care coordination for international students, and triage of critical issues from groups and sales. And so the parties have historically used this nanny over previous summers. I think they both understood Ms. Kroll's demands in her job. And I think we all as professionals can understand that it's extremely difficult to focus and 100% on your job when you're trying to juggle two kids at the same time.
Okay.
Which
And
she
then-
does do during 2 days, but I mean, to do that 5 days per week full time is just not conducive to her role.
And then what about this offer of free childcare?
I believe that what they're referencing is Dr. Kroll's offer to have his mother care for the children. My understanding is while the parties were married, they historically did not use his mother to provide summer childcare because she would charge them. They've used this nanny Molly for, like I said, since Elena was 3 years old. So this is someone who the children are familiar with. And my client is not in agreement with Dr. Kroll's mother providing childcare for the girls. I don't think that it's his choice to dictate who provides childcare during her parenting time.
Okay, thank you. Mr. Norman?
Not sure I have much.
The math on these cases are absolutely insane because if they were still married, living together, they both would not be paying $5,000 to $6,000 per month to support the children. But with child support, you essentially become a math equation. So women in these positions are often incentivized to not work as hard or to get promotions because she makes more money with them split apart than if they were together. Essentially, she has another full-time job where she doesn't work at but receives $70,000 a year for. When you add on top of this the threat of no-fault divorce, you're beginning to see why men are making an active, rational decision to abstain from marriage.
Else to add is, the allegations as far as not contributing to some of these expenses, it's not entirely accurate. Quite frankly, that's the purpose of the upwards deviation of the $5,000. It was intended to include all of those things that they're complaining about now. As far as, yeah, that's correct. It's primarily Mark's mother, the grandmother of these two girls, who these girls have not been able to see at all for 6 months at least now, because of the plaintiff and what's going on here. I don't want to wade too far into the weeds on this because we're waiting for this custody evaluation report, which we're expecting this week. And quite frankly, as a result of that report, which we've already agreed will become the controlling parenting time order in this case, there could be a significant change in custody and parenting time. So this objection, it may be moot. Her request for additional child support, that also may be moot. We're not exactly sure yet. I think if we were going to go forward today, maybe take this under advisement pending receipt of this custody evaluation, and then we're going to make some adjustments to child support anyways, I anticipate. So I'm not sure I have much else to offer here. I don't understand, maybe Ms. Umulis could explain in greater detail the objection to a grandmother spending time with the grandchildren. That doesn't make any sense to me whatsoever. Also, with a 12-year-old child who cares for other children, I still don't understand the reason why childcare is needed in the first place here in this instance, especially with the plaintiff working from home. It just seems like an unreasonable request for more money. We have beliefs that this entire litigation is a attempt to increase the child support obligation and just deny Mark any relationship whatsoever with his children. And this is just further evidence of that as well. But like I said, I don't want to go too far into it. We've agreed to adopt the custody evaluation as the parenting time order in this court. So, I would say let's just wait and see what that report says, and then we can address this objection and this request after we receive that.
Ms. Umulis, do you have any?
Great interjection by the man's lawyer right here, and essentially all of my points as well. She's working from home, but needs all of this money from a nanny. Make it make sense. Gentlemen, if you know that your ex is a blood-sucking vampire, make sure that you invest into a lawyer to fight on your behalf.
Objection to the court, I guess essentially adjourning this and just lumping it in with everything else outstanding?
I would have an objection to that. I understand that we may be dealing with a change to the child support going forward, but these are expenses that are being incurred over this summer. They're not, my client is in need of financial assistance with these childcare costs. If child support is going to be modified going forward, these are still legitimate expenses that she's incurred for this summer for childcare. And with respect to the allegations about Dr. Kroll's mother, I don't know how she's been prohibited by my client from seeing the kids for 6 months. She has full capability to see the children during Dr. Kroll's time. There's no order that prohibits her from seeing the children. And
I guess I didn't really want to open up a whole.
Okay.
I asked a narrow question, and you want a decision today, so that's what we'll do. All right. This is Emily Kroll versus Mark Kroll. This has been a hearing.
Can I say something really quick?
Yes, Dr. Kroll.
Sorry, I don't work on Fridays, and so if there's ever days when there's daycare on Fridays, I'm always free. So I guess I'm confused as to why the 6-hour rule would not work on Fridays when I literally have every Friday off.
Well, is there, Mr. Norman, Ms. Umulis, is there a question of fact as to whether the right of first refusal might be utilized in place of the nanny in this case?
the nanny is not utilized on Fridays. I believe the nanny's utilized Tuesday, Wednesday, Thursday.
It's not true because she's dropped them off on Fridays, but okay.
All right. So at this point, it looks like, there might be some evidentiary issues. The court is just relying on offers of proof today. Mr. Norman essentially has made a request to, I think, adjourn this and conduct an evidentiary hearing on these issues. If I hear you correctly, Mr. Norman.
That would be fine, Your Honor.
All right. Well, since there are outstanding fact issues, I guess primarily regarding the dates on which this nanny is actually providing care. And I think that it is relevant that if she's providing care when Dr. Kroll would otherwise be available and if Ms. Kroll is aware that he is available and the right of first refusal has been requested and refused in place of the nanny. I guess in light of all of that, there are some issues that need to be sorted out. So for all of those reasons, I will go ahead and I will grant defendant's request to adjourn this hearing. We will conduct this in an evidentiary fashion. It will be added to all other outstanding child-related issues, and the order from today will reflect that. Thank you.
Thank you, Your Honor.
Just one point of clarification, the adjustment will continue.
All prior orders, including the adjustment, will continue in full force and effect. For what it's worth, I'm not going to. I'm just going to say that the child support assessment will continue, as will all prior orders in full force and effect. To the extent there's an argument that this is an impermissible charge under the terms of the consent judgment of divorce, I have some opinions on that, but I'm not going to weigh in at this time because the court has not issued I guess, a ruling on the objection.
Great job on the judge here in being fair and making sure that all of the facts were presented and all of the statements were true. And with that being said, his child support will continue with not an increase. And I think that that is a happy ending to stop a bloodsucker. Guys, leave me your comments down below. What do you guys think about this case? Do you agree with me that she's doing too much? Do you not agree with me? And really post why you do not agree with me. I'd love to see your answers. Questions, comments, concerns? Y'all already know what to do. Mediocre tutorials and reviews at gmail.com. Until next time, YouTube.